here we go. This is April 10th, 2019. This is going to be, I hope, a short class on the Tax Injunction Act and the Anti-Injunction Act. We're covering pages 1061 to 1093 in the Hart and Wexler Casebook, 7th edition. And before getting to the Anti-Injunction Act, I want to talk about two other statutes described at the beginning of page 1090. They are the Tax Injunction Act, which is Section 1341 of Title 28, and the Johnson Act, 28 U.S.C. 1342 on utility rate regulation. These statutes were enacted in the 1930s at a time when the federal courts had a reputation for favoring business interest against state regulation and taxation. You may recall the Lochner era. That's what we're talking about. So before the West Coast Hotel versus Parish case in 1937, the case that ended the Lochner era, the Supreme Court used the notion of economic substantive due process to favor business interest. The idea was to channel this kind of litigation to state courts where Congress thought would be less sympathetic to business interest and more sympathetic to state regulation. There's been little litigation involving the Johnson Act. I do want to know the reason it accepts Commerce Clause challenges probably here is the perceived problem to dealing with the economic due process theory. So let me make a couple points about the Tax Injunction Act. First, federal courts can't enjoin or suspend collection of state taxes if there exists what's known as a plain, speedy, and efficient state court remedy for disputes. You recall some of the issues that we saw in other cases were that there were tax collection matters where there was no remedy for the taxpayer who wanted to get the taxes back. They couldn't afford to pay them in the first place. So a seminal case on that is Reich v. Collins, which has been in the casebook. We've seen it a time or two, and I'll mention that here in a second. So the requirement is that there has to be a plain, speedy, and efficient state remedy. So what does that mean? Roswell versus LaSalle National Bank is on page 1091 in the casebook, and Roswell says that a remedy that does not include interest to be paid back on your tax refund and takes 2 years is adequate under the Tax Injunction Act. Well, what if the plaintiff sues for damages? There's a case called Fair Assessment in Real Estate, which is at the very bottom of page 1091, going up to page 1092. And the Supreme Court says that a policy relating to federalism, comity, applies to state courts situations. And comity forecloses damages suits. So you're not going to be able to sue for damages in a tax situation in federal court based upon the Tax Injunction Act. What happens if the plaintiff sues in Section 1983, even in a state court? Well, there's a case called National Private Truck Council on page 1093 that says that the anti-federal involvement policy embodied in the Tax Injunction Act is not going to allow you to sue in state or federal court under 1983. The point, however, is not that there's no damages in tax cases. You need to recall Reich v. Collins, and that case holds that a state must follow its statute that provides for refund of illegally collected taxes. The favored alternative is to use the procedure provided by state law. Obviously, that's the whole point of the Tax Injunction Act, is to keep the federal courts out of state tax matters. And Reich, as I understand it, requires that state law must have either some post-deprivation or pre-deprivation, or if you want to put it as pre-collection or post-collection due process remedy that allows the taxpayer to fight it out in state court. The Supreme Court's most recent ruling on the Tax Injunction Act is a 2015 case called Direct Mail Marketing Association versus Broll. It's not discussed in Hart and Wexler's, but you can find a discussion at page 800 in the Chemerinsky book. Colorado had a statute in that case that requires out-of-state retailers who under then current dormant Commerce Clause jurisprudence could not be obliged to collect and pay sales taxes to Colorado based on their residents' purchases. They required those out-of-state retailers to report tax-related information to Colorado purchasers and to Colorado tax authorities. Essentially, Amazon would have to report to Colorado state tax authorities how much Coloradans were spending on Amazon. The retailers challenged this in a 1983 lawsuit in federal court as a violation of the Commerce Clause, and Colorado argued that the 1983 lawsuit was barred by this Tax Injunction Act that we're talking about. The Supreme Court ruled unanimously that the Tax Injunction Act does not apply to this kind of a challenge. Under the language of the Tax Injunction Act, the lawsuit did not attempt to enjoin, suspend, or restrain the assessment, levy, or collection of state taxes, and therefore the Tax Injunction Act was inapplicable. The court also said that it wasn't taking one side or the other on the comity doctrine here. It just wasn't before the court. Now, although that Colorado case remains good law, the practical effectiveness of it has now been rendered completely moot, because in late 2018, in a case called South Dakota versus Wayfair, the Supreme Court ruled that states may charge sales tax on purchases made from out-of-state retailers, even if that out-of-state retailer had no physical presence in the taxing state. So that's the Tax Injunction Act. Primarily, you just need to know about it. Let's talk about the Anti-Injunction Act, which is 28 U.S.C. 2283. So, by its terms, a federal court cannot grant an injunction to stay a proceeding in state court except 1, expressly authorized by Congress, 2, where necessarily in aid of its jurisdiction, or 3, to protect or effectuate its judgments. You can look at this slide and see that there are 3 express exceptions that we're going to talk about. So this act does not bar a federal court from granting an injunction to prevent the commencement of a state court action. It only applies if there is an ongoing state case, and it's aimed at barring federal court injunctions in ongoing state cases. So the Anti-Injunction Act was originally acted in 1793, and history is not very helpful on what the heck the framers were thinking here. The notes suggest that it was aimed at what was happening with circuit riding Supreme Court justices, that, as y'all will remember, prior to 1800, the justices rode circuit. The Adams administration changed that and stopped it, and then the Jefferson administration, 2 or 3 years later, reinstated the notion of Supreme Court justices riding circuits. And the history tends to suggest that this act was directed at the problem of individual Supreme Court justices when they were on circuits interfering in state court actions. So it's been recodified, and regardless of what happened in 1793, it's pretty clear that it means what it says. So before discussing the 3 exceptions, it's worth noting that there's actually one more exception not stated in the statute but real. It does not apply to suits brought by United States or on behalf of federal agencies. So if a federal agency sues in a state court or in federal court, the Anti-Injunction Act against an ongoing state proceeding does not apply. The other note here is that the Anti-Injunction Act is not flexible. It's not a rule of discretion. It's a pretty strict rule. And so if you want to stop a pending state proceeding, you have to show that one or more of these three exceptions apply. In looking at how the Anti-Injunction Act has been interpreted over years, the most important case is the one at page, I forget what page it is, sorry. It's the Atlantic Coastline case, the first one in the case book. And it's also discussed in the Mitchum versus Foster case that we're going to get to here in a second. Despite earlier cases suggesting otherwise, when you get to Atlantic Coastline in the early 70s, and this is what we're referring to, pages 1078 to 1081, there was a case called Tucci. There was before the Tucci case, the Anti-Injunction Act was interpreted to be flexible. The Tucci decision said it's not flexible, it's rigid. And then there was post-Tucci cases suggesting that maybe we needed to go to a flexible standard again. But that's just history. So what you need to know is the second bullet point applies. It's not flexible. There's a set of rules. So here are the three statutory exceptions. I've mentioned them earlier. You can't get an injunction against an ongoing state proceeding unless it's been expressly authorized by Congress, if it's in aid of the federal court's jurisdiction, or to protect or effectuate its judgments, which is essentially the federal court can step in to protect an existing federal court judgment from being relitigated in state court. That's why I call that the relitigation exception. So the litigation in this area is going to focus on which of these three statutory exceptions apply. So let's look at the Atlantic Coastline case. In 1967, a federal court declined to enjoin picketing. Then the state court actually enjoined that picketing in a labor dispute. In a separate case called Jacksonville Terminal, the Supreme Court of the United States held that the state courts couldn't do this when a federal court had already enacted. And so in the Atlantic Coastline situation, the federal court went in and enjoined the state court proceeding that was effectively going to, in turn, stop the picketing. And in the Supreme Court Atlantic Coastline decision, it ruled that the federal court's action was wrong because none of these three exceptions apply. Now, here in Atlantic Coastline, the expressly authorized exception simply was not at issue. But the question would rise, why wasn't the relitigation exception at issue? Because the federal court had declined to enjoin the picketing. Well, it's a bit murky, but I think the key point is that the federal court in 1967 did not make a final judgment in that sense. So then the next one is, why wasn't it necessary to aid the federal court's jurisdiction? Well, the argument evidently is in the first paragraph under Section B, is that the Jacksonville Terminal ruling by the Supreme Court invalidated the state court injunction. And here the court said that the invalidity of a state court injunction is not a ground for invoking this second exception, the in aid of. That's a little bit all murky, so let's keep going and see if we can find some better expressions of it. If you look at page 1068, note 13, you'll get to the Smith versus Bear Corporation case. It's in the notes, but I think this is a good illustration of the third prong, the protect or effectuate its judgments relitigation exception. So let me just tell you what happened in that case, because it's a little bit unclear even from the note. There was a suit filed by a person named McCollins in West Virginia, which was more or less a products liability suit seeking damages for a prescription drug called Baycol. McCollins sought a class action, but Baer removed it to federal court on diversity, and then under the class action rules, it was transferred to a multi-district panel in Minnesota and consolidated with a bunch of other lawsuits involving Baycall. At the same time, there was another set of litigation in West Virginia called the Smith litigation. The claims were similar to those in the McCollins suit and involved Baycall. Smith was also seeking certification as a class action, but it could not be removed to federal court because there were West Virginia defendants, so there was not complete diversity. So over the next 6 years, those cases are going along their separate pretrial paths roughly at the same pace. And by 2008, both courts were preparing to look at their respective plaintiffs' motions for class certification. And the federal district court in the McCollins case was the first to reach that decision. So that court, which by that point in time was in Minnesota, in McCollins' case, declined to certify the proposed class. The why is important here. It said that under West Virginia tort law, a plaintiff would need to show, quote-unquote, actual injury in order to win. And because that showing would necessarily vary from plaintiff to plaintiff, there were individual issues of fact that would predominate, and that's one of the reasons why you don't certify a class. So under Federal Rule 23, the case was not suitable for class treatment. So the court also dismissed McCollins' suit on the merits because he could not show actual injury and he did not appeal. So what did Baer do next? It asked a federal district court in West Virginia to enjoin the ongoing state-based Smith litigation and to not certify a class in Smith. And it argued that under the Anti-Injunction Act, Section 2283, the federal court could apply the third exception to protect or effectuate its judgment in Minnesota. And the argument from Baer was it was identical to what happened in Minnesota and the same result should apply. And I'm sorry, I've said that they went to a federal district court in West Virginia to do this. They actually went back to the same Minnesota federal district court where the McCollins case had been handled and made this motion in that action saying you need to enjoin the Smith West Virginia case. The federal district court agreed with Baer. They enjoined the state action and the Eighth Circuit affirmed. So then the case comes to the Supreme Court, and the Supreme Court ruled that this third relitigation exception did not apply. The court said you need two things for this third exception to apply. First, the issue that the federal tribunal decided must be the same one as presented to the state tribunal. And second, the court said Smith must have been a party to the federal suit or else must fall within a few discrete exceptions to the general rule against non-binding parties. Remember, the first federal case is McCollins versus Baer. Smith's not involved. The second set involves Smith. The court said neither of those two prongs applied there. So on this first prong, Baer pointed out that Rule 23 has been adopted in West Virginia, so why isn't the issue the same? Well, the court flatly rejected the notion that textual identity between federal and state law means that the issues are the same. So what the court has to look at is whether state law parallels its federal counterpart. This is going to be done on a case-by-case basis. And what that examination reveals here is that West Virginia state courts follow a different practice in applying Rule 23, even though the text was the same as the federal courts did. So the class certification issue is not handled the same way substantively in West Virginia state courts as it is handled in federal courts. And thus, because of that difference, the Supreme Court in Smith versus Baer said that this relitigation exception was not applicable. So one of the things to keep in mind on this is that with the adoption of the Class Action Fairness Act, CAFA, these rules might be a bit different. So I'm pointing this out mainly so that you will flag it and know about it. The protector effectuates its judgment exception is also discussed in Note 3 starting on page 1086. And there's some general points that I'd like to make that don't necessarily come through in your reading of Atlantic Coastline or what I just talked about in Smith versus Bear. The general aim of this third exception is to address the situation when someone has won a federal court case and the loser in federal court then brings an action in state court. That's why the Supreme Court in Smith versus Bear was talking about the fact that Smith wasn't involved in the McCollins case. The state court ought to apply the notions of collateral estoppel and res judicata to bar the loser from relitigating it. But the point of the exception in the Anti-Injunction Act is that the federal court winner doesn't have to rely on what he thinks might or might not happen in state court. He can go to the federal court and enjoin the state court proceeding. So that raises the question of why not just go to the state court and say res judicata, collateral estoppel, he's barred. Well, you can do that, but there can be some problems. Look at the Parsons Steel case, which is in Note 3 at the top of page 1087. In that case, a plaintiff sued the bank in separate state and federal actions. The federal one finished first, and the bank won. The state court in that case rejected the res judicata defense, and the Supreme Court said that the federal court must respect that judgment. So in Parsons, what the bank should have done is they should have had the federal court put in place an injunction against the state court proceedings in the first place, which the Parsons Steel defendant wishes it would have done, rather than depend upon the state court applying issue and claim preclusion correctly. So the lesson that Parsons Steel teaches you from a practical matter is that reliance on the state court is risky because the state court may not agree with you, and then you would be bound by what the state court decision is. So the notion here is if you've got a federal court judgment on the same basis and the loser goes into state court, you need to go to federal court and get an injunction based upon this third exception. If you look at Atlantic Coastline, there's another key point I need to make, and this is in Section 2B on 1071 and 1072. And that's the notion is that the fact that the same matter is being litigated in both state and federal courts may not be enough to trigger this exception. And what Atlantic Coastline is talking about there is it refers mainly to a situation where the federal court has some case in front of it first. And while it's being litigated in federal court, somebody brings a lawsuit in state court on the same matter, and the notion is that the state suit somehow threatens the federal court's ability directly to deal with the federal one. So here's the best example, or the easiest example, is let's say you've got a case about the disposition of property, and the issue is who gets the property. And you're in a situation where the state court lawsuit threatens to answer that question and have the property disposed of in some way before the federal court can do so. An example of that situation would be a federal bankruptcy proceeding because it's an in rem proceeding against all the world. So in a federal bankruptcy proceeding, think about the estate, the assets and debts of Alpha Company is at issue. Beta Company sues Alpha in state court for a breach of contract, trying to recover some of Alpha's assets. In that instance, the federal court may enjoin the state court lawsuit under the second exception of the Anti-Injunction Act in aid of its jurisdiction, because if the state court lawsuit allowed Beta to get Alpha's assets, then it has defeated the purpose of the federal bankruptcy proceeding. Now, sometimes you can remove the state court proceeding and combine it in federal court, so that's another option that you need to look at too. Another example would be where you have exclusive federal court jurisdiction, say patent law. So suppose Alpha and Beta have similar patents. Alpha sues Beta in state court for patent infringement. Beta sues Alpha in federal court. Can the federal court enjoin the state court proceedings? The general answer here is no, they can't. And look at page 1083 in Hart and Wexler, that note for the answer there. The third exception is the injunctions expressly authorized by Congress. And that brings us to the Mitchum versus Foster case. And in that case, let's talk about what happens. A district attorney in Bay County, Florida, files a state action to shut down a bookstore as a public nuisance. The state court grants a preliminary injunction shutting down the bookstore. And the owner there seeks an injunction in the Northern District of Florida Federal Court alleging First and 14th Amendment violations. The Northern District denies injunctive relief, relying on Atlantic coastline. And the question before the Supreme Court was whether the expressly authorized language of 2283 permits federal court in a 1983 action to grant an injunction to stay that state court proceeding. And in Younger, a year earlier, which we're going to see in the abstention cases here in a few days, the Supreme Court expressly declined to take on that case. But here, the Supreme Court reasons that if 1983 is not within the expressly authorized exception to the Anti-Injunction action, then that statute would have absolutely barred the injunction issued in Younger. And thus, if the court is going to rule in a particular way, it's going to have to overrule Younger and its cases. So what the court looked at is the Anti-Injunction Act was in 1783, and in 1948 they've recognized several exceptions, including several federal statutes in page 1079 and implied exceptions that I just mentioned to. The court in Foster said that does 1983 expressly carve out an exception? And the answer was no. And so look at page 1076 at the bottom. And that's based upon cases decided under the old flexible approach. And so one point of the case is that the exception does not really turn on whether it has to be expressed. So let's see if we get this. So the relevant factors from Mitchum versus Foster, page 1076, the statute does not need to make an explicit reference to the expressly authorized language. The statute need not expressly authorize an injunction of state court proceeding, but Congress must have created some kind of specific and uniquely federal right of remedy or enforcement in a federal court of equity that would be frustrated if the court could not enjoin a state court. So the test there is whether an act of Congress is clearly creates a federal right or remedy enforceable in a federal court of equity that could be given its intended scope only by staying the staying the state court proceeding. So 1983 doesn't make any explicit reference to enjoining state courts. But what the court said there, what the court said was that the aim of 1983 was to fundamentally alter the relationship between federal and state courts in the realm of constitutional challenges to state action. And thus, on page 1077, 1078, the court said 1983 creates such a specific and uniquely federal right that if the federal court did not have the power to enjoin state courts in this situation, it would be eviscerated. So Mitchum versus Foster holds that 1983 satisfies the expressly authorized exception of Section 2283. Here's another example. Look at the Vindo case on page 1082, note C. That involves the Clayton Antitrust Act, which is a federal statute that provides for exclusive federal jurisdiction in antitrust cases attacking agreements not to compete. So the question was, is the Clayton Antitrust Act an express exception to the Anti-Injunction Act? And it comes out differently from Mitchum versus Foster. It says no. That was a case where there was an attack on the validity of agreements not to compete. There was a state lawsuit seeking to enforce the agreements, and the Supreme Court ruled that the Anti-Injunction Act barred the federal courts from enjoining the state court proceedings. So why isn't the antitrust statute within the expressly authorized exception? Look at page 1082 toward the bottom. The court starts with the Mitchum test, which is at 1077 at the top, but the court finds that the Clayton Antitrust Act does not meet that test because even though the action for damages conferred by the Clayton Act, like 1983, is a uniquely federal right or remedy, it is not a statute that can be given its intended scope only by allowing injunctions against state proceedings. It didn't redress the federal-state court balance the way 1983 sought to do. Because in federal antitrust law, there was not a policy that was based on some concern about curbing what state courts were doing. So let me come back to a point that I made a few minutes ago, I hope, and then we'll end with a couple of other things. Don't take from Mitchum that there is no obstacle to bringing a 1983 in order to enjoin a state proceeding. A year before Mitchum was decided, the court had already instituted, or rather reaffirmed, a judge-made rule requiring abstention in many cases of this kind, which is younger, which means that in many cases, the federal court's going to say, we are abstaining from getting involved until the state court proceeding has run its course. So there are obstacles to enjoining state court proceedings under 1983, even though Mitchum versus Foster says that's an appropriate route. So we'll come back to that in Younger the next time. Let me be clear about one other thing, which is that, and this is about state court relations and federalism, state courts have absolutely no power to enjoin a federal court proceeding. Absolutely none. And there's a case called Donovan versus City of Dallas that hits on that point. Finally, let me just cite you so that you can look in your book at this and keep in your memory somewhere one day if you need this. There's an act known as the Civil Rights Removal Act, 28 U.S.C. 1443, on page 856 of Hart and Wexler. We did not cover it in that section of removal. And it applies in two situations. First, a defendant in state court can remove to federal court if she can demonstrate that the state court proceedings will deny her rights created by federal civil rights statutes. And secondly, you can get removal to federal court if your defense is that your action was required by federal civil rights law, or that you were being sued or prosecuted for failing to act in a manner prohibited by a federal civil rights statute. That's a statutory created limit on state court action and jurisdiction. So you may never need to know that. You may never need to use it, but it's out there. So I hope that you can follow along with this. If you have questions, let me know. Otherwise, have a good day.